which we're going to hear a lot more about in a moment. And what we wanted to do really was to put authors in conversation who have similar interests and themes, but maybe the areas of kind of geographic areas don't speak as much as they could to one another. And so we think this is a really fantastic opportunity to speak about family law and politics in both South and East Asia today. And we're very lucky to have two wonderful speakers to start that conversation. And so I'm going to introduce our speakers and then speak a bit about the format, and then I'm going to pass over to pass the microphone over. So our first speaker today is Dr. Mara Du, whose research centers on the history of modern China in 17th century to the present, particularly with an interest in law, gender, and state building. And our first monograph, which we'll hear more about in a minute, is called State and Family in China, Filial Piety and its Modern Reform, which was published by Cambridge University Press in 2022. And it won the 2022 International Society for Chinese Law and History Biennial Book Prize. So congratulations. Our second speaker, who is joining Mara, is Dr. Soumya Saxena, who is an associate professor at the Jindal Global Law School. And her research interests include legal history, gender, family law, secularism and politics in South Asia. And her book, Divorce and Democracy, A History of Personal Law in Post-Independence India, was published also by Cambridge University Press in 2022. So before I hand over the microphone to our speakers, a bit on format. So our speakers are going to speak for roughly 16 to 18 minutes each. And then we're going to have some time for questions between the two speakers. And then I'm going to open the floor to questions from our audience. So if you have a question, you can either raise your hand when the time comes, or if you would like to type it into the chat box, I'm also happy to read it on your behalf. So we can come to that when it's time. But with that, I will pass as I said, pass the microphone over to Amara. And thanks for both of you. Thanks for joining us.
Many thanks to the organizers and to Dr. Saxena for allowing me to join this conversation, and especially giving me the opportunity to read Soumya's very exciting book. So for sake of time, I would just jump in. Yes, into the presenter view. I'll try to be, oops, not this one, this is the last one. Okay. Thank you. So I will give a brief introduction of my book and its central argument, and its a little bit implications, especially in consideration of Soumya's book, and I will focus on the modern part more than the pre-modern part. So my book is called State and Family in China, Filial Piety and its Modern Reform. So the book really started from a Chinese word. It's called 国家. So if we want to translate it, it's actually difficult to find a counterpart because the 国, the first character, can be translated as nation, state, country, empire, polity, dynasty, regime. So it has many faces. That's exactly how the multifaceted word 国, or so-called nation, influenced China's trajectory in the last 1.5 centuries, is the topic of my current book project. But then my first book project is on the other side of the story. That is the relationship between the 国 and the other word 家. Here you can see. It's also difficult to translate, but it's a bit more straightforward than 国. It usually means family, or household in the pre-modern modern context in China. But it also started from hereditary noble family, just as 国 started from hereditary noble state. So 家 also means hereditary noble family. But what I try to emphasize in this book is this: there was such a strong connection, and there is still strong connection between the 国 or the nation or the state part and the 家 or the family part, that it's very embedded in the language, that when Chinese speakers are talking about nation or state or regime, they literally refer to as state family. And how what state family means changed really tremendously from pre-modern to the modern context. That's the trajectory I try to show with my book. And of course, filial piety or intergenerational hierarchy lied at the center of this transition, and that lies at the center of my story. And also, even though, as a writer writing English, I need to make it more accessible to the audience. So I use filial piety. That's the most commonly used translation of filial piety of Xiao. But actually, I mean this character. So it's elder, this part, over the zi is the child, this part. So it's a hierarchy. The child is under the parent is above the child. It's sometimes it's sentimental, it's a filial piety, it's a love or reverence. Sometimes it's just a hierarchy, instrumentalized, legalized hierarchy between parent and child, with or without the sentiment. Okay, so state-family relations have been a very important topic in Chinese history, and I listed many wonderful works here and more in English language literature on state-family relations, both in pre-modern China, like Jenny Tai, Matthew Summer, Xiao Baohua, these different aspects of state intervention of family relations or state regulation of family relations, mostly in the Qing, sometimes in the Ming Empire, before the Qing Empire as well. And these wonderful works are on the legal reform in the first half of the 20th century to see how the state sort of led the reform of family structure and the relationship between that reform and state building, nation building in the 20th century. So why I still write a book on this? One of the reasons was I think almost all the discussion of state-family relations in late imperial China and the state-initiated family reform in modern China focus on conjugal or sexual relations. And I'm not saying that it's not important. I think I'm a gender historian myself. I publish in terms of paper a lot of gender history works, but I do feel in the Chinese context, it is this overlay or exclusive focus on conjugal or sexual relations is a result of the centrality conjugal and the sexual relations occupied in politics and the society, not in historical China, but in contemporary China due to Western influence. So, and this is our modern bias that predisposed scholars and the readers to focus more on gender relations. Of course, all history is contemporary history, but we also need to honor internal logics of non-Western societies in the pre-modern context. That's where I wanted to start my work on intergenerational family relations. And of course, there are also people who have discussed intergenerational family relations, but mostly from the perspective of rights, like mourning rights or sacrifice, or from the classics, right, the discourse or the sentiment, rather than from the perspective of the law, as in the gender part, right? So that's, I think, my that's where I think my contribution will lie, is to show basically how gender became so central in the first place, because it wasn't the case in pre-modern China. And there was a saying, a sentence that was widely accepted almost by anybody in pre-modern China, that was ruling all under heaven through filial piety. It was accepted by the emperor, the literati, the people, and how that even changed to be the family relationship that center on gender and man, the relationship between man and woman. That was the trajectory I want to focus on. So this is a book that hopefully lies at the intersection of legal history and the political cultural history. So it's not just about the politics, but it's not just about the court records, about the legal practice either. So it's about the relationship between them. And I hope it lies at the intersection of gender and the generational relations. And I sort of use a word that's not exactly words like subjecthood, this sort of terms. It's called generational. So I think pre-modern Chinese family relations, especially its legal aspect, was gender and generational. So it's very difficult to define whether it's gender sometimes or it's purely generational. It's generational, but my book hopefully lies at the intersection of gender and generational relations. And also, I look at both the pre-modern, establish the centrality of filial piety or intergenerational family relations to state governance in pre-modern China, and then to look at how it changed in 20th century China. That was a Republican period, a little bit into the post-1949 period, and I look at the continuity and change. So I won't delve into the local archives and central level archives I use, but I want to show the structure here. That so the book is divided into two parts. The part one is on the team. So it's called Ruling Empire Through the Principle of Filial Piety. Basically, it shows how, right? And the second part is called Building the Nation Through Restructuring the Families, the 20th century part. And in each part, the first two chapters is on the empirical, so on the concrete legal mechanism of state regulation of family relations, especially intergenerational family relations. And the third chapter, right, is chapter 1, chapter 2, that's on the team part. Chapter 4, chapter 5 is on the Republican part. And chapter 3 and chapter 6 are discussing the relationship between the parallel relationship between state regulation of family relations through law and the political logic of governance. So that's the structure. This is the Chinese version. And for the sake of time, I won't delve into the pre-modern part, but basically what I try to show with these two chapters on the empirical was the first chapter is on the logic of parental infallibility. Basically, parents can never be wrong. So it was enforced through many very concrete, localized legal mechanisms, such as the children would be punished for accusing parents, even if the accusation proved to be true. That means almost impossible for adult children and minor children to defend their own rights. And for the parents, it's the opposite. Parents and grandparents, they could falsely accuse their children without any penalty, etc. And then the parents were also authorized to report to the county Yamen, or the Yamen was a judicial administrative complex, to have the unfilial sons beaten or being put in the cage, and this and that, without showing evidence. Basically, just the court would take the words of the parents, right? And they could also request the child to be exiled to the frontiers, and the cost would be covered by the Qing government. And then, but on the other hand, the children, even if their parents were trying to kill them, they accidentally injure their parents in self-defense, or they just argue with their parents with good reason, and their parents commit suicide, these children would be executed in many cases, slicing to death, right? The lynch, right? Dismemberment. Still, sometimes you can see in the deliberation of the juries, they will say, like, obviously the parent was wrong, but for the children, there was no way, like, the parents were wrong. So the children needed to obey, even though from the third party perspective, the parents were doing something horrible or wrong. So in the end, they try to uphold the notion that being obedient to parents was being righteous. And that's about parents can never be wrong. And also the structure was always for empirical chapters, always started from one very dramatic case. In this case, like father-in-law raped daughter-in-law, daughter-in-law killed father-in-law, and then the father-in-law tried to send his own son to be punished by the county Yamen, and the son died, and the father-in-law reported it's an accident, and then the daughter-in-law killed the father-in-law. So it's always very dramatic in all these four empirical chapters. And then usually this dramatic case would speak to at least four, sometimes at least three, sometimes four of the sections, the institutions. And then in each section, there will be many, many more cases brought in. It's very similar structure. And then chapter 2 really tries to show the people were very resourceful. They tried to use the court. They killed their own kids to falsely accuse their neighbors to get a small payment, this and that. Or they falsely accuse other people of being unfilial. But in using the court, they bought into the logic because that was the best way they could benefit themselves. And that was one of the reasons why the court or the state, actually, they were aware of this abuse, but they tolerated it because it served their ultimate goal of letting the people buy into this generational hierarchy. And the third chapter will see the logic that was of the Qing regulation of filial piety. It was really the logic of indirect rule, that the emperor regarded himself as parenting all under heaven on behalf of heaven. But also it wasn't like he was father, mother to the people. Also, he referred to the governor as father, mother to the people under the governor's jurisdiction on behalf of the emperor. And then the magistrate as being the father, mother to the people on behalf of the superior authority. So it was a hierarchy of hierarchies that the commoners' parents and grandparents, this sort of hierarchy was at the bottom of this delegation chain, hierarchy of hierarchies that served the purpose of ruling the empire at a very low cost, and because everybody was trying to regulate the people below them and serve the people above them, and they felt good about it because except for the very small children, they were always superior to somebody else. So it's sort of the logic how the empire could be ruled with a very small fiscal state that the government actually didn't need to pay for the people to maintain order, and how to prevent the state from falling into feudalism, very small like authorities, like even both in the family realm and in the state. There was a logic in Confucianism. It's called united under one authority. That was the lower authorities were unable to join higher authorities, but the middle level authorities could be overridden by the higher level authorities at any time. So it was not just in law, in family, but in ritual as well. So it was a ritual principle that could be applied across the board. So it helped to hold these hierarchies together, and et cetera, et cetera. So I won't delve into details. But for the modern part, so why the change, right? How it changed. And in chapter 4, I look at the basic, this redirection, reorientation, that in pre-modern China, the parent-child relations really focus on the parents' privileges. And in the 20th century, the legal reform tried to focus on the children's rights. For the minor children, the right to be raised well, to be taken care of by the parents, and for the adults, the rights to sue their parents to protect their own interests. And the most important thing I think happened in the 20th century was the introduction of the very notion of legal majority in terms of not just in terms of criminal intent. In pre-modern China, legal majority was there for criminal intent. Like for very young children, if they kill somebody, people thought, he or she couldn't make his or her own decisions, et cetera, et cetera. But that's for other purposes. In terms of parent-child relations, in pre-modern China, that was a lifelong privilege for the children. So in 20th century, legal reformers were like, even the sons in their 40s and 50s were obliged to obey their mothers and fathers in their 70s and 80s. So it was a lifelong privilege. It didn't end until the children reached adulthood. But in the 20th century, it was very important that the legal notion of the self-determination, the age of self-determination is 成年自主之年, that was introduced that would enable adult children. Yes, their parents were still their parents and to take care of them or respect them, but that's it. The parents were not authorized, as in pre-modern China, to control adult children's authority, property, their marriages, their places of residence, their choice of occupation, nothing. It was really just like nowadays we have, my parents are, my mom is still my mom, right? Even though I'm an adult, but that's totally different. That's the parent-child relationship between from the change from a lifelong parental privilege to transitory guardianship that resulted in a change in marriage, because now for adults, they should make their own decision in their marriage. And that's what was exactly the core of the marriage reform of 20th century China, that once the children reach a certain age, the marriage was their own matter, and then their parents had no power whatsoever. And it was also related to the management of property, that for adults, if you earn your money, that's your money, right? It's not your parents' money. They couldn't control that money. And that resulted in many different consequences, not just in terms of filial piety or in the generational relations in terms of the authority, but also elderly maintenance, because it wasn't an issue in pre-modern China. If you cannot sell your land, you need your mother and father's signature to sell your land. That's different than in the 20th century, that the breadwinners, the young people, they contribute their own money. Then the elderly maintenance became an issue. So it was a total overhauling of society. But why it happened? Why the state was so enthusiastic about this sort of reform that freed people from family units, and not just for them, there are two sides: the wives from husbands, right, and also the adult children from parents. And of course, that was for the purpose of state building, as in the late Qing reformer Yang Du's words. The purpose was really to implement the spirit of statism, and the purpose was to, here it says, 必使国民直接于国家，不间接于国家. So our goal is to make the subjects or citizens directly connected to the state, not indirectly connected to the state. So everybody, their productivity would contribute to the state rather than their family, right? And he said, China has fallen because there are too many benevolent fathers and filial sons and good elder brothers and obedient younger brothers, and too few good subjects or citizens, right? And also it was exactly also the logic of 20th century legal reform of the making of the 1930 Civil Code, 1935 Criminal Code that are still in effect in Taiwan today. And the purpose, the lawmakers, they were very explicit about it. When liberating people from the control of the family, the purpose is not for their own rights, rather it's to facilitate them to serve society and the state to the biggest extent. Then, the state family, 国家, changed from a state changed from a family writ large in the pre-modern time, right? The structure was very similar, and function was not function, but structure was similar. It's a delegation of parental authority from the emperor to the parent. Two, in the modern world, in the 20th century, the state was the only family that truly mattered. And to the extent, in the Cultural Revolution, so that's in the epilogue, that lesson 1, your father's dear, your mother's dear, but Chairman Mao is dearer than both of them. So that goes to extreme during the Chinese Cultural Revolution, but that's the big arch I try to show with my book. So I have run off of time, but so yes, I'll turn the screen back to the organizer. Thank you.
Oh, should I start? Okay. First of all, Mara, thank you so much. I almost wanted you to keep going because I was enjoying it so much. And I feel like our works kind of like speak to each other in such a significant way that I'm tempted to now focus on areas that actually speak to your book in some way or the other. But I'll start with a general introduction of the book. But before that, of course, Alistair, I want to thank you for inviting me to this and for this format and for HKU to be hosting this event, and I'm really glad to be part of it. And I believe on Indian family law, I wasn't sure how much context the audience might have. So I'm going to begin with a quote from one of my least favorite members of the Indian Parliament in 1955. And this is the time when people are debating the Hindu Marriage Act, and this will go on to be codified by the end of 1955. This is in context. This is like the first social legislation that India is taking up post-independence. And they're thinking about ways in which you can codify marriage between two Hindu people. And the quote goes, "The great essence of Indian civilization is the purity of the family, the great ideal of chastity and the great ideal of Indian womanhood, which has been our pride and glory through the ages. Such a measure, like divorce, has never been put before an electorate. Isn't this time of a communal legislation repugnant to the spirit of the Constitution?" So N.C. Chatterjee is the man who makes the statement, and in one stroke, his speech kind of ties the idea of honor to womanhood to a glorious civilization, and puts the burden of preserving this glory onto the law. So the law is then meant to be something that preserves this in the ideal of Indian, in particular Hindu family. And the Hindu Marriage Act is, of course, trying to introduce divorce as multiple grounds for divorce, which are available to both partners. And there's a lot of opposition from many members of parliament to this. Now, marriage in Chatterjee's view is often regarded as an institution that is not only meant to protect women, but also promote the idea of a family. It's incentivized through the state, through tax benefits, housing benefits, and so on and so forth. And social movements and feminist jurisprudence, on the other hand, would do precisely the opposite, which is highlight the pitfalls of marriage. They would highlight everything that is wrong with them, the unequal ground for divorce, the kind of gender biases within marriage. They would seek marital rape to be accepted, violence within a marriage to be made sort of legible and something that should be acknowledged. And thus, we could say that while state values a marriage, democracy has historically loved a divorce. So it's kind of it was this kind of made divorce a very interesting lens for me to kind of view democracy, because on the one hand, we have all institutions of the state, be it court, be it parliament, be it social movements, be it individual judges and parliamentarians and people of significance. They're constantly in this conversation, which is about marriage, and it exhibits their anxieties about divorce. But very often, the conversation doesn't stay about marriage. It becomes about the larger, longer trends in democracy. So it would become, for instance, about secularism. Now, just for background, we know in India, we have family law regimes are divided in a way that we have personal status laws that govern marriage, inheritance, adoption, and guardianship, minority, all of that. So basically, the entire bundle of family laws is governed by Hindu personal law, Muslim personal law, Christian personal law, Parsi personal law. They've all been codified as separate statutes. But alongside all of this religious personal law, which is codified or uncodified, there is also a civil statute that people can voluntarily opt into if it's, let's say, an interreligious marriage. Or if people want to opt out of the religious code, they have an act called the Special Marriages Act, which they can opt into if they don't want to stay in a religious regime. Now, the default position is that you're born into a religious personal law code, but upon marriage, you can decide to opt out of it. And once you opt out of it, your children inherit according to the general Indian civil law, but you inherit according to your parents' personal law. So it is kind of confusing, which leads me to make three broad arguments around family law in India. Now, the first argument that the book works with is that very often gender is the entry point of the conversation, but the debate never remains about women's rights. It will end up becoming about Muslim personal law versus Hindu personal law versus constitutional law. It will end up becoming about secularism, about religion. It will end up becoming about national integration, whether so many different personal law codes should be allowed to persist or not. But the conversation, the easiest entry point for the state to have a conversation on family law becomes gender, because gender is something that they think that social movements will rally behind, and feminist jurisprudence in India has, particularly in the last couple of decades, it's become very pronounced, it's become very powerful. So there's a lot of writing on feminism in India and legal reform, particularly legal reform led by women in India. So gender, I argue, is actually merely an entry point for the state to actually have a conversation, and what they end up doing is actually reordering religious relations in certain senses. What they're also doing, and this leads me to my second point, modern religion, very often as a consequence of this process, is being written in courts. Very often, what emerges as Hindu, Muslim, and Christian personal law codes is borrowed somewhat from the Shastra, the Sharia, or all of these, religious documents or whatever we recognize as central texts of religion. But these texts of religion are sort of competing for relevance alongside a lot of civil law. So it leads to a kind of a weird situation where codified personal law is accused of two things. The first thing it is accused of is that, what the state has codified, it actually doesn't agree with religion. It has no link to the sacred, and the state has actually codified an inauthentic version of Islam, or an incorrect version of Hinduism, or a wrong version of Christianity, right? So the codified law is the problem, but religion is all right, right? So that's one argument around which personal law gets a lot of criticism. The second argument around which also gets a lot of criticism to personal law in the way in which it's been codified is the fact that these religious laws actually contradict civil law, and they contradict fundamental rights that the Constitution guarantees. Now, a lot of initial early 1950s, 60s, 70s feminist jurisprudence was kind of leaning on this to challenge ideas of religion and to say that, oh, this is an inherently unfair practice, and we will challenge it by saying that the way in which state has codified it, it kind of, codifies inequality, and therefore we want amendments. So, in some senses, it became really interesting that the minute you put religion onto the statute, the general idea would be that the minute you make a law around something, you give it more rigidity, right? You make the law more rigid. But in India, precisely the opposite happens in the limited realm of family law. The moment you put religion onto the statute, it becomes subject to tremendous public debate. So people will challenge it in Supreme Court and say, oh, this is not religious enough. They will challenge it in different courts and say, oh, this is not aligning with fundamental rights. So actually what it creates is that it opens up this ambiguous space for people to question various aspects of religion as well as civil law. And therefore, this leads me to my third major argument of the book, which is that all ideas of secularism, divorce, marriage, they are not static entities in India. They're constantly evolving because the law is not able to offer any fixity or offer any rigidity. What it ends up producing is even more incoherence. And it is with this ambiguity that you actually see an evolution of the way in which divorce was imagined, right? So let's say we started with a quote by N.C. Chatterjee that says divorce is this repugnant idea. It goes against
I think we just lost Soumya for a second, right? I'll just make sure. Let's see, I'm sure she'll be back in a second. She's just joining, I think, again. Just be 1 minute, I think. Hi, Soumya. We had you at Chatterjee. That was where we got you to.
Okay, so at Chatterjee. So I'm sorry, I just lost my train of thought, but I'll get it back in a second. So what we were talking about was the third argument, I think, which is about how law and divorce and secularism and all of these don't remain static entities, but they're constantly infused with new meanings as citizens interact with the state. So what Chatterjee said in the beginning about divorce being something that is repugnant to Indian democracy, repugnant to Indian womanhood, an idea that has not been put before legislative rigor ever, gets kind of challenged over the subsequent years when in 1980s some of the biggest state interventions end up being about divorce, right? So in one sense, these ideas on marriage, divorce are not remaining static entities because the state is trying so hard to actually get religion onto the statute, and then it's leading and it's creating a space for all of these conversations that challenge what could be the authentic interpretation of religion. So now in the second part of my presentation, and hopefully the internet will continue to support me, in this part of the presentation, I'm going to take a couple of examples of what happens when this ambiguity is, affecting the day-to-day lives of individuals when they're approaching the state with their problems. So one, because the book is actually mainly interested in the shadow of the law. It's not interested in big legal reforms that happened and, periods of history that are kind of divided according to this reform happened and then this major case and then this new legislation. But it's actually about the legislation that couldn't come into being, or the kind of law reform that there was a conversation about, but it didn't, or how potential law actually changed the lives of the people without even becoming a law. It was a potential law, right? And to contextualize this, I want to take a few examples. And the first one is this very creative ruling in 2001, which is reinterpreting whether Muslim women should get maintenance upon divorce. So at this point, of course, Supreme Court is a stage for more than one battle. It is not just about a conversation between a husband and a wife, but the wife's petition for divorce and maintenance upon divorce has been joined by a whole bunch of NGOs. And the husband's petition has been joined by All India Muslim Personal Law Board and a lot of religious organizations. And then you add another layer to it, different political parties start to support them. So in one sense, the courtroom in India becomes a stage for more than one battles. And when this battle is taking place over interpreting Muslim divorce and whether or not women should get maintenance, one of the things that was really interesting to me is that this one judge picks up a word. The word is called mata. And he says that this is an Arabic word and we are trying to use it in Indian jurisprudence and we're trying to interpret Muslim personal law in courts here and align it with constitutional ideas. So he says this word mata has been completely misinterpreted in history as maintenance. Mata meaning maintenance for women or the wife, right? But actually, he says what it means is not maintenance, but a provision for maintenance. So by sort of going into the complexities of language, he actually makes a one-time maintenance idea into a provision for maintenance. And in one sense, he did something very interesting because he aligned the constitution with the Quran. So one of the really common trends that you notice in South Asian jurisprudence is that while religion and state are competing for relevance, very often they're also leaning on each other for legitimacy. This becomes one example in which religious law is reinterpreted to say that, look, there's nothing to protest here because Quran and the Constitution essentially say the same thing. Now, let's say this conversation happened in 2001 when the Supreme Court gave a new interpretation. It upheld the law, it upheld religion, and it also made sure that the woman has a provision for maintenance, right? So it becomes almost, I could say as a historian, we've come to this argument late, but it's pushing me towards a more anthropological argument that actually the law, when it comes to family law in India, can mean whatever you want it to mean. Because if you will not find constitutional support for it, you would lean on religious ideas. If you don't find religious ideas that align, you could say we want to reinterpret religion. And a really good example of this, again, I'm taking it from Muslim personal law because, so that it's just, one community's religious code that we work with, given that we have limited time today. So in India, recently, there was another big court case about another aspect of Muslim personal law, which is that the man has the right to give women divorce by simply saying the word divorce or talaq 3 times orally. And if he says it, that pronouncement is considered as final divorce. Now, this was contested by by a woman. Again, her husband's petition was joined by Muslim Personal Law Board. Her petition was joined by a bunch of political parties and a lot of NGOs and non-government organizations kind of supporting the cause of feminist jurisprudence. And the conversation took a really interesting turn because they said, we want you to get rid of this practice, not because women of other religion in India, don't have to suffer it, but actually there are provisions in the Quran that say that this is the worst form of divorce within Islam. And therefore, what this NGO ends up saying, so this also means that at one level that the voice of the petitioner and the respondent is somewhat subdued because it's a much larger conversation. But the larger conversation became about how feminist jurisprudence or Islamic feminism in India is drawing from global movements to say that we are going to reinterpret religious texts. So even if the court wants to come in and say that we want to give centrality to religion and recognize essential practices, these NGOs begin to question who gets to tell you what authentic religious practice is. And how this plays out in court, of course, is predictable. It was a predictable order in the sense that, again, court ended up saying that, yes, triple talaq is a terrible practice and it should not happen. And the constitution says it should not happen. And the court says it should not happen. It contradicts fundamental rights. It contradicts religious tenets. And therefore, we do away with this practice. What happens when women or these organizations don't take a case like this to court? So this NGO, which was supporting this woman for the triple talaq case, also runs its own sort of counseling forums. Now, these counseling forums are not legally recognized in the sense that they're just forums, and the kind of orders they pronounce will hold no legal value. But nevertheless, it's interesting because they say that we work within the ambit of religion, within the discourse of tradition. Therefore, when women come to us, they work like a semi court structure. So, what they would do is they would also call the man and they would call the woman, and they say, look, we're going to interpret your case before you go to court, according to Islam, according to the Quran, and tell us what the facts of the case are. So, very often, men and women would have a conversation, they would give you the facts of the case, and then they would say, something like, no, but this is an incorrect interpretation, therefore you can't give this form of divorce to your wife. And men, if they don't respond to the summons of these women qazis, of these women centers, they would informally lean on male qazis and say that, why don't you summon, maybe he'd listen to you. Another interesting example, and this might be the last one I'll take in the interest of time, is that there are also informal, I shouldn't say informal, they're formal but recognized organizations called the Darul Qazas or Islamic courts. Now, again, even their orders are not recognized as legally valid, but nonetheless, they function. And in these Darul Qazas, the judges are often male. So these male judges, in my experience, it was really interesting because you would think that they're claiming to interpret everything according to religion. But let's say if one of the women petitioners has brought along with her a woman from the NGO, the lady who's working as a legal aid helper would just get up and say, oh, Mr. Qazi, this argument will not hold in court. So do you want to revise your fatwa or your decision a little bit? And very casually, the judge would think a little bit about it. And he would say, okay, now this is an interpretation of Islam. And, and he would end up giving a slightly more favorable order. All of this is to basically make an argument for interlegality in terms of how much religion sort of makes its way into Indian courts, and Indian courts have the ability, and Indian legislature has the ability to rewrite modern religion. But equally, modern law is also making its way into its way into religious forums, and in some way, it's a really interesting conversation that women tend to use to their benefit, and the ambiguity that actually seems quite scary can be seen as something that is actually getting much greater compliance from community, because you can manage to convince people that you don't have to give up your religion to get rights, right? So which is the big contention in feminist jurisprudence, that religion is suppressing you, therefore lean on abstract rights. And that argument has been systematically demolished in India, where you can say that no, you can claim your religious identity and there is a way to go about legal religious reform. I do want to say more, but I think in the interest of time, I will stop here. And I'm looking forward to the conversation with Mara, because I think the next bit that I had to say was very much in conversation with what she just said. About one of the contemporary measures that the Indian government has taken towards divorce, but I'll leave that for the question answers when we do talk about it.
Okay, thanks a lot, Soumya. So what we'll do is we have about 10 minutes now for our authors to speak. And in the meantime, for audience, if you have questions, please start thinking about them. And like I said, message me on the chat box, or I'll raise your hand when the authors have finished conversation. So I'll put whoever, if you have any questions for each other, please feel free to ask away.
So actually, I have some comments and sort of questions, but mostly I feel, in my notes, there were 4 points I think I want to really bring up here. The first 2 points, I think Soumya's work really and my work resonate with each other. And the next 2 points, I think I learned from Soumya's work. And I think even though it's too late for my first book, but I think that this will be instrumental in my revision of the book manuscript of my second major project. So the first is about ideas. So the interesting thing that really occurred to me when I read Soumya's work is sometimes the religion or whatever religious tradition that was brought up in this debate, or what occurred to people to be the religious tradition, might not necessarily be the religious tradition the philosophers or scholars get from the text. Sometimes it could be quite detached, but And that's why, Soumya said that sometimes religion, I don't know whether it's a word like made in the court or made in this sort of discourse. And that was a religion that really influenced people's understanding of the religion, because it's not like people are very, just read and think about the scripts every day. Rather, they just look at the news and how that religion would affect their family life. They think, oh, this is Islamic tradition. Well, if you're a scholar, you may disagree, but the problem is for the majority, actually, it is Islam for them. And it's very similar thing that occurred in the pre-modern Confucian context, that many of the things that the state claimed to be the teaching or state claimed to be the Confucian part, or people believe it was a Confucian or whatever. But if you go all the way back to Confucian texts, and then you figure out, actually, probably it wasn't. It departed from the Confucian spirit. For example, reciprocity, right? And the Confucius, when he discussed this filial thing, or this lower party or the inferior's submission to the superior, he often started from the superior's responsibility to the inferior. And so but that part was ignored in lawmaking, in judicial practice, in the emperor's discourse. But then people actually, after 2,000 years, when they discuss these Confucian principles, the Confucian principles in their mind was the Confucian principles in the law that they could use for their own benefit. So I think there's very interesting dynamic here. And I think that's where the legal scholars can work on, not just on how the thought, the ideas of religion influence law, but also the other way around, right? And how law, and also if we treat law as a language of politics, how law and politics influence religion and ideas. And the second is, and your emphasis on this legislative process. So I really love, how you approach law, because you said like, this book is not a book about law itself, but the book about the politics of lawmaking. I think it's so important for the contemporary legal scholarship, because sometimes, especially for legal historians, I think sometimes it's so easy, so straightforward, just go to archives, look at the court and get something. But sometimes, from my own experience in conducting research for my first book, I first started from the, of course, like everybody else trained in the West, like I started from the secondary literature, etc. But when I was in the field, I first look at the court records, and then look at these edicts or legislative documents. And then I realized a lot of the patterns I found in the court records were already well articulated by these jurists during the time. So I think, I just don't know whether maybe it's not a question or two back. What do you think about this general trend of students, delving directly into the archives without paying enough attention to this discourse, which can be very important? And for the next 2 points, I really think that's where I really lamented. Oh, I should have delayed this book, read your book, and then read my book. I read your book and read my book. And the first is about your articulation on the fractured nature of the state and of non-state actors. I think my handling of it in my book was not sophisticated enough. Sometimes, when I talk about state as if they were all on the same page, but actually the local states and central states, central government and the local county government might have different interests there. I do feel you really got that part out, that, it's not the state, but different states, and the court, and then the legislation, the executive, they all had different agendas. Sometimes they played into it. But also non-state actors, they were also not on the same page, that the elites and then the people from different religious background, or the commoners, or the different groups, they also had their own agenda. So it's not just, oftentimes we discuss, the state versus the non-state actors, but actually it was the state actors versus each other and the non-state actors versus each other. So it's this sort of very complicated process. I hope, sometimes I lose something when I do this very long durée research, because, as a first-time writer, that there's a word limit, so sort of like how to lose all the things. But I think in the future, in some of my other works, I really would love to look at this fractured nature of both groups. And also there is the fourth point that is so important. Sorry, my notes are a bit. Yes, the fourth point is something that really struck me as so insightful. So you discussed this dual pulls of constitutional liberalism against democratic sanction. So it was so pronounced in some of the cases, but I didn't get the theorization in my first book, because there was very similar issues during the late teens. They tried to reform the civil code, a criminal code on the. So my focus was on the intergenerational, but other scholars have discussed the gender relations, etc. But issue was, it was very ironic that the National Assembly half of the members were appointed by the Qing court, which were already very determined to reform. Half of the members were elected from the provincial assemblies, and the provincial assembly members were elected from the society. And the conservative members were actually the elected ones. They didn't want too radical reforms, the reforms that were too radical, but the appointed members were the people who pushed the reform. And then the appointed members, the reformers, compromised, manipulated legislative procedure to get the code passed. So if we discuss the code today, people would think, oh, what's the point of this conservative? Like, how you can punish the unmarried women for adultery, or how you can let the parents go unpunished by killing their children? It's not possible. But that was a result of this 1 century of reform. So people's mind already changed. But if you give it to a democratic process, then the reformist labor law would not be passed. So it's sort of like tension. But I didn't theorize it. I just felt there was an irony paradox here, but you theorize it to show that in these non-Western regions, some of the liberalism was actually introduced by the constitutional process that was not native-born, right? And then the native-born thought sometimes would tend to be more conservative, in the sense that, if you value liberalism or constitutionalism, then you sometimes you fight against democracy. So it's interesting and very troubling paradox here that I feel you articulated so well in your book, and that's my point. Thank you.
Thank you so much. Those comments were actually so valuable. I wish I had taken more notes when you were talking. And I feel like even I really wish that I had read your book, because, I'll talk a little bit about the immediate connections that I made when I was just listening to you talk, and when I read your book. And the first one was that when you were talking about, these multiple layers of authority, and generally how invested the state is in this idea of filial piety and family, it reminded me of a recent, like a recent event in India, where one of the states, Gujarat in India, one of the western states in India, they tried to build parental consent into marriage as a compulsory thing. So this very idea that parents should determine who their children should be with, they wanted it to be added as an amendment into this Hindu marriage law, so that people can only marry with parental consent. Now, this parental consent, so I was like reading your work and listening to you, I feel like it has a very specific impact on marriage, which I think I would have really benefited from had I read your book. We published in the same year, so that's unfortunate we didn't have a chance to read each other's work. But it was a really good point, because when these cases kept coming to my mind, so there was another recent case in India which also reminded me of some of the things that you were saying. So in the state of Uttarakhand, which is a northern state in India, there were a set of parents. They filed a case against their son and their daughter-in-law, because they said these kids have been married for about 6 years and they've not given us a grandchild. And they sort of put all of these allegations of cruelty. So it kind of really showed me this idea of ownership that people have towards their children. And actually, even in India and South Asia, there is a lot of this conversation and a lot of religious mythological anecdotes about the responsibility to parents. And parents very often are also held akin to gods in India. Also, because Hinduism can be it's such a polytheistic religion that it's completely comfortable with the idea that a past grandparent or a parent who's passed on can actually, their images can be placed in the temple that you maintain at home. So they literally have that godly status. And that, I think, really affects the way in which, it not just affects the family, but it also affects marriage. It also affects the kind of relationship. And here is when I would kind of word some of my comments as questions, so that we can also start to take more questions from the audience if there are any. But I would love to hear more from Mara about this. um one of the questions that I had was that when there is a marriage and between a man and a woman, does her allegiance to her parents change, in the sense that has she got greater allegiance to her in-laws? Because one of the things that struck me about the Hindu Inheritance Act is that when a widow dies, let's say if her husband is dead and then the widow dies, the property of the widow goes to her in-laws and not to her own parents. So let's say first the husband passed and the wife inherited the property, and then the wife passed, and of course her kids will inherit. But if there are no kids, then it goes in under Hindu law to the in-laws and not to her own parents, because marriage is meant to sort of consolidate a new unit for the woman. So there are also cases in India with regard to this, and this is the last example I give, I promise, from India. One of the cases was that if a woman moves into a new marital home and she wants to live in a nuclear family, in the sense that she doesn't want to live with her in-laws, in one of the cases, the husband kind of filed for divorce, saying that this is cruelty. So separating a man from his family or from his parents, even after marriage when he's an adult, was understood by the Indian courts as cruelty, whereas separating a woman from her family was kind of seen as tradition, because the woman is seen as transitioning from her parental home to her matrimonial home. So I was wondering, how much does marriage impact one's relationship? I mean, does the allegiance or the responsibility towards parents change in that sense? And it also made me think, particularly the bits that you had written about killing of children, and the fact that there is such great ownership over children that even to accuse a neighbor of something, you could actually commit that crime and commit that murder. It really made me think about the way in which, even in India, we've never had to fight for abortion laws, because killing a female child in the fetus was extremely common. So female feticide and female infanticide immediately upon birth was just so common that it meant that not fighting for abortion meant that pro-choice was anti-women in India. Basically, they've never had to fight that battle, because it's so commonly accepted that, of course, there are now laws against this, but traditionally it was so common for female feticide and infanticide to happen, right? So in one sense, this kind of ownership over children, that you can sort of take life, was very interesting to me. So I was wondering if you could talk a little bit about that in context of abortion laws, if there is any link in China. And the first question being about the impact of marriage on filial relationships.
Maybe you could both take the question you want to answer the most, and then if we have any questions from the audience, then we can kind of also have a little bit of time, if that's possible, because it's got to that might be the best way to do it. So if you could maybe have like 2 minutes answering and responding, and then we can go to the audience. That's all right. But thanks so much.
Okay, so maybe I can jump in to hopefully I can address some of Saumia's questions as quickly as possible. I think in China there was a big change between the pre-modern and modern that happened mostly chronologically during the some of them happened in the late teens, but most of them in 1930s. So that's why the pre-modern family and modern family were so different, operating on so different logics. And in the pre-modern family, it was patrilocal, and first the parents own children, so they could kill their own adult children with very little consequence. Actually, not to mention infants, it was just like nobody really would intervene. Partly because due to the language, also the sheng or produce or create and giving birth or begetting, it was the same word in Chinese. So often the legislators or the jurists, they would say like, of course your parents begat or give birth to you, because of give birth to you, they will heaven. It's like heaven created grass. So what's the point? Like they could kill you. Like That's in the language, it was obvious, but if we translate it as English, because there were different words for different, like creation and birth, of course, is a different word. So you will feel odd. So that's a thing that, and also the marriage was very patriarchal. So the women, the bride's family usually would ask for the bride price, the colorful gifts. So that almost like transferred ownership of the daughter to the husband's family. Then after that, her filial duty was to her husband's parents, but also her own parents got the compensation in money. So it was a like common practice in transactional family. And once she didn't have the daughter-in-law didn't have property inheritance rights, but she had the custodial rights over her husband's share of estate if she kept chastity. So she would always remain in that family, and her property would never revert it. In late imperial China, it was different in medieval China, like to her natal family. And in the 20th century, everything changed so dramatically. Like, so the blood is called 血亲, so blood relative. That was how the law defined family relations. So in theory, after 1930s, the adult man, adult woman, they marry each other. It was a small unit. They could choose to live by themselves or with any size of parents. Nobody would care. Like, it was not about the law. And daughter inherit her parents' property. The son inherit his parents' property. But if, for example, the husband got the property from his parents, and then he died, the property goes to the wife, and then the wife died, the property could go to her parents. It's just like, it's all became very individualized. And it's, in terms of law, it was gender neutral, it was super westernized, but it doesn't mean it's the same thing in practice. That's why there was a big gap, even today, that people expect their daughters-in-law to fulfill certain duties, and then the bride's family expected colorful gifts or the bride price, and bride price could be extremely high. But then, legally speaking, the daughter-in-law had no obligation whatsoever. So there were also like tensions caused by this gap between the law and what is expected in society. Yeah, that's it. Yeah.
I'll also just take a minute to, as quickly as I possibly can, and I'll broadly address the bit on, sort of tradition versus modernity conversation about how religion is treated as is very often seen as the conservative side, whereas modern law is coming in and introducing, let's say, liberalism and constitutionalism in India. But I think what has happened is, in contemporary context, the idea of family law reform has become completely appropriated by the Hindu nationalist majoritarian political party. What this has meant is that the liberal idea has now become to protect Muslim minorities or to protect Christian minorities, to protect difference. Because Hindu majoritarianism is all about seeking homogenization through the country, and they're pitching uniform family law as a kind of an argument against, the obscurantist practices of Islam and Christianity and so on and so forth. Very often the liberal argument has now become minority favoring, right? The secular argument now is an argument in favor of preserving religion. And what this has done to modern depictions of religion is that it is no longer a very clear dichotomy between religion versus law or religion versus modernity, but religion itself is exhibiting itself in uniquely modern ways. So religion is now becoming sort of, that contest has changed a little bit, has changed quite significantly. So, for instance, in this entire idea that, modern law is entering these informal forums, it has kind of meant that the way in which religion is to be interpreted is no longer fixed. And because it's not fixed and it's an evolving process, it can no longer be very clearly pitched against modernity. Because let's say modernity is what is represented by fundamental rights, constitutionalism, so on and so forth. Now, this entire will to say that actually the argument for removing religion from public domain and introducing a uniform civil code, because it has become a right-wing political argument, the argument for reform has now become very within religion reform, within the discourse of tradition reform. And I think this is contingent also on regime change in India, because the old left position is, of course, that they want to get rid of religion and modernize in a way that, it is complete uniformity across all religions in India. So that was the old left-wing argument. Now that has become the Hindu majoritarian argument, and therefore the left has had to shift its position in India. And that's actually doing very interesting things to the way in which religion is being pitched. now it has become, I mean, which is all basically to say that constitutional liberalism is now being looked at as something with limits, because I mean, it's a weird choice that women are having to make between religion and abstract rights. So now the argument has become that you should be able to embrace religion and still access rights, so that the Hindu majoritarian state is not kind of bestowing these upon you, but you can be like a good practicing Muslim and still have access to religious as well as constitutional rights. And that's doing some very interesting things to the family law debate in India because of how contentious the issue is at the moment. And I do feel like we could just go on, and if it weren't for the time, would love to connect with you even after this so that we can keep this conversation going.
Okay, we have two questions. First, I have one from Chunhei Justin Fang, who asks, Soumya, as per the Indian case, it is mentioned that the Indian court would strike a balance between the constitutional rights and the religious practice and avoid making both of them contradictory. So how would the court interpret the Muslim regulations of the Quran in order to make it comply with the law naturally, but not distorting the original meaning of the religious text?
So it almost definitely distorts the original meaning of the text, which is why the minute religion goes onto the statute, it is immediately vulnerable to challenge. It is immediately vulnerable to challenge by religious groups for not codifying it correctly, by feminist groups for actually compromising fundamental rights. So so basically the sources of, let's say, Islamic jurisprudence in India or elsewhere would be Quran, Hadith, Qiyas, and Ijma in that order. So Quran being the book, Hadith being the life of the Prophet and the lessons from it, Qiyas being the opinion of the qualified, of people who have knowledge of Islam, and Ijma being a debate, Ijtihad being a debate or a conversation through which jurisprudence evolves. Now, this is not how it actually. So India would never actually admit that they're actually putting religion onto the statute. They would say that they're a secular country and all their laws are therefore secular. And it does have a common criminal code. It has a common civil code. It's only in this tiny arena of family law that there are some parallel statutes. So there'll be a Special Marriage Act, but there'll also be a Dissolution of Muslim Marriages Act, a Hindu Marriages Act, and a Parsi Marriage Act, right? So these statutes are the ones that are really vulnerable to contestation. They neither carry authentic versions of religion, nor are they completely aligned with constitutional values. But what this does mean is that it allows the court a lot of freedom in interpretation. Because let's say the legislature will just write the law, and it will be a bunch of people sitting in parliament who will do their best to interpret essential practices of religion and try to interpret it in a way that doesn't go against the constitution and put it on statute. Now, in a lot of ways, they would also do away with practices that are essential to religion but are very obviously problematic. For instance, dowry. Now, there is an anti-dowry legislation in India, or practices like sati, for instance, or widow emolition, which were banned in colonial India. So there was more jurisprudence, like there was more legislation on this in 1980s as well, which kind of also makes the glorification of this practice, it disallows the glorification of this practice. So very often it would confront religion, and it would actually say that that law is a way in which we confront religion and do away with traditional practices that are, anti-women or anti-certain castes and so on and so forth, right? But what it allows is that the courts, in their own little way, will every once in a while try to find some common ground between these two, which becomes a very pacifist kind of jurisprudence. But what it also means is that nobody has any monopoly over authentic religious knowledge in India anymore. So every time you say that this is the version of religion that is true, it is a version that is contestable. It's a version that can go to court, and the court can actually say, oh, but this side says this, and then there'll be 3 NGOs who join and they say, no, we are these kind of religious organizations, and this is what it actually says. So it's basically open to a lot of contest. So in one sense, these legislations are making inequality legal. They're putting certain small inequalities onto the statute and onto the statutes. They're making them legal, but they're also making them challengeable and amendable. The minute you see that inequality preserved in a statute, you know there is a method to challenge it. And that is what's making both religion and the law extremely malleable and subject to challenge. I'll stop here.
Okay, Mike, I think Mike has a question for Mara.
Yes, thanks very much for both of the fascinating presentations. I have one quick question for Mara. Thanks so much for pointing out the effect of Confucius idea. Actually, the effect of the distorted Confucius ideas in the legal text and legal discourses and imperial edicts, which actually led to many unfortunate consequences, even in the contemporary world, because one of which being that even in today's, in common law legal education in Hong Kong or elsewhere, it's very common to see a legal textbook when they talked about the legal cultures or underpinning ideas of legal cultures, legal traditions of China, they would point to the fact that it's largely based on, if not solely based on, Confucianism. And hence, so many problems they attribute to Confucianism. So how would you respond to these conventional narratives or what I say cultural essentialization claims? If you are going to correct those legal textbooks, how would you say, what's the underpinning ideas of Chinese legal cultures, family law or otherwise?
I would say there are two kinds of Confucianism. Confucianism as value that has a lot to offer to the contemporary world. And that you can read the text and get the abstract value that it can be gathered anywhere, right? And the other, that's how a lot of new Confucian scholars today are doing. And it's really admirable. And also it was many of the new Confucian scholars in the early 20th century, such as the drafter of the 1946-47 Constitution, Zhang Junmai, was doing. So they treated Confucianism as an abstract value. The other side was Confucianism as historically manifested institutions. That's where we got a lot of so-called Confucianized lore in the team that for Han Confucians, we think, what is Confucianism? I think there's a thing that so Professor Cai Liang is working on this debate on collective responsibility during the Han Dynasty. That was so shocking for me as a Qin historian, because in the Qin, everybody assumed, even by the Qin people themselves, collective responsibility was a Confucian thing. That's how Confucianism was introduced to law. But according to her research, actually the Confucians during the Han Dynasty was against collective responsibility. So what we can see about it, then maybe it was Confucianized law, Chinese law in late Imperial China, but it was a Confucianism they believed to be Confucian that might be very different from what we can get from Confucian texts that I think is to some extent universal and not just to contemporary, not in terms of temporality, but also in terms of space. But that's another story.
Okay, maybe I can just ask the final question then, and then we'll, because we've already run over time. I really enjoyed reading both of your books together, and both of them, what struck me about both of them, so my first graduate supervisor in my master's, she was a historian of family, but her book was 25 years ago written, and she always told me that when her book first came out, it was a real struggle to convince a lot of scholars of historians that she wasn't doing something marginal, that family was something that was political, and you could reread big debates through that question. And then when I read both your books, which were published 20 years later, you both tell such powerful stories about how the state and major transitions are happening in 20th century China and India through the family. And I was wondering, how did you find, have we as a field moved on so that it isn't hard to make the case that you don't need to, the family isn't marginal, actually it's central to the major questions of both, say, Chinese or Indian history? Or did you have struggles to convince various parts of the field that has those old habits died, or I was kind of interested in that kind of reception about working with big questions in the family. Is that struggle still ongoing in the field, or yeah, that was really my kind of one of my big questions on styles.
Okay, should I go first? Okay. Okay, so this is actually a great question because when I entered the field, I thought of it as a very crowded field because a lot of people were working on family law and legal reform. And I think in India, there was a very distinct period in 1985 with this major case in Shah Banu, from where I picked up the definition of the word mata as maintenance versus provision for maintenance. So that was a big case that started in 85, concluded in almost 2001, saw new legislation. And after that, the politics of family law had become something that people were really talking about. And it's interesting for me to separate then the family from family law, because family law became a very crowded field. But as a historian, I can also put this scholarship in a trajectory, right? I can see that after a certain point, it's picking up, and in 1980s, everyone's writing about family law. But the conception of the family, the anxieties around divorce, I found it pretty consistent in, late colonial India up till pretty much now. So let's say the anxieties surrounding divorce or breaking of families. So many scholars have also said that, state is an ally of the family. Srimati Basu writes about it. State is also an ally of a certain kind of family. State is an ally of a family which is a within religion, within caste marriage, and is, of course, a heterosexual marriage in this case. So the state is protecting a certain kind of a family, and that family is protecting with all the trappings that come with a patriarchal marriage, right? So in a new law in 2004, there has been one Indian state which has enacted a uniform civil code in the state of Uttarakhand. So they have said that we've done away with all religious law. We've introduced a uniform civil code. And in this uniform civil code, there is this one provision which says that even if you live together for 1 month, you have to register that union as a live-in relationship, because if you don't, that can lead to sort of, all sorts of problems for women. So it's again couched in the vocabulary of we're doing this for women. But what it also shows is this anxiety around separation. So if it is a heterosexual unit, the state wants to make that unit legible, because very often making a marriage or making a heterosexual relationship legible to the state means that you can hide a little bit of violence in that marriage. So for instance, in India, we have this thing called a marital rape exception. Rape as a crime has seen a lot of advancement, lots of new laws. But when it comes to marriage, they say it's difficult to establish whether rape occurred, or was it like where was the consent? How do we determine it? So it's called a marital rape exception, and that's been preserved in jurisprudence, right? Similarly, there are laws like restitution of conjugal rights, which basically mean that if it's a violent or a difficult marriage and a woman moves away, a man can file a case for restitution of conjugal rights, and the state would order that the wife return to them, or the court would order that the wife return to them. Now, all of these ideas tell you that basically violence within marriage is very often hidden once the relationship becomes legal and formal. That anxiety, I don't think, has changed in the last 20-25 years. I think it's becoming even more pronounced now. So I feel like this generation, this generation is also marrying more because divorces are becoming simpler, so marriages are becoming more common and divorces are becoming more common. But the centering around the family, the state's vision of a family, is still very fixed, even though scholarship has moved significantly from not talking about gender and family as a central unit for nation state and the creation of new nation states, particularly post-independence in South Asia, to now acknowledging how important it is for questions of democracy, secularism, so on and so forth. But the state's conception of the family is still quite stuck in time, I would think. And that's still something that I've had to work with. And, the quotes I found in 1950s were not very different at all from what I found in 2021. So, that was disappointing and strange in very many ways.
Yeah, so I would try to be very quick. First, I think we are in a very fortunate time for family studies, partly because family, I think when I was in PhD program, nobody would think family was not related to politics. It has already become ungiven, but also for Chinese law. I think my advisor, Joanna Willicott, often made joke with me. She said when she was in PhD program, she said, I'm going to study Chinese law. They would say oh, you will be able to finish very quickly because China had no law. But now it's such a big field. So I think it's just a development of scholarship that people change their attitude. And I think now people understand that family is not just about women, right? And it's about men and women and everybody, and it's about gender. That gender is not woman, right? Gender is both sexes, and also it's about the state. So I think it's easier. But also I think my book actually traced the process through which family became not the center, or at least not as central as the pre-modern. So that's why my last chapter is titled "A Constitutional Agenda." That's really about how people became atomized. The state wanted everybody to be the one single cell connected to the state, and it is so much related to the very strong state of the 20th century China, that authoritarianism, a strong tax extraction, this and that. I think because it's everywhere, I didn't feel the pressure, and I don't expect in the future family would become less important in terms of the discussion of law and politics. And I can only be grateful.
Thanks so much. Thank you so much. So I can thank you both so much for such a wonderful conversation. It was so nice to see so many sparks flying between the two of you of ideas and things. So this is our last talk of the term and the academic year. So we will be back next year with some more talks. But well, then, thank you all for joining us. Thank you, Mara and Soumya, for such a wonderful discussion. We really appreciate having you both. And I think, Michael, is there anything else you wanted to say for us?
No, just thank everybody for joining. Thank you so much.
Thanks
I'll
so
see you
much.
in the next semester.
Thank you.
Thank you,
Thanks very
Mara. Thank you,
much.
Sonia.
Bye.
Thank you so much.